Hello friends, myself Mohit and I am going to dictate you Steno legal matter. Please subscribe my channel and press the bell icon for more dictations. So be ready for the dictation. 5, 4, 3, 2, 1, start. The position that emerges from the above discussion can be summarized thus: the power of the High Court in quashing a criminal proceeding or FIR or complaint in exercise of its inherent jurisdiction is distinct and different from the power given to a criminal court for compounding the offences under section 320 of the code. Stop. Inherent power is of wide plenitude with no statutory limitation, but it has to be exercised in accord with the guideline engrafted in such power to secure the ends of justice or to prevent abuse of the process of any court. Stop. In what cases power to quash the criminal proceeding or complaint or FIR may be exercised where the offender and victim have settled their dispute would depend on the facts and circumstances of each case, and no category can be prescribed. Stop. However, before exercise of such power, the High Court must have due regard to the nature and gravity of the crime. Stop. Heinous and serious offences of mental depravity or offences like murder, rape, dacoity, etc., cannot be fittingly quashed even though the victim or victim's family and the offender have settled the dispute. Such offences are not private in nature and have serious impact on society. Stop. Similarly, any compromise between the victim and offender in relation to the offences under special statutes like Prevention of Corruption Act or the offences committed by public servants while working in that capacity, etc., cannot provide for any basis for quashing criminal proceedings involving such offences. Stop. But the criminal cases having overwhelmingly and predominatingly civil flavor stand on different footing for the purposes of quashing, particularly the offences arising from commercial, financial, mercantile, civil, partnership, or such like transactions, or the offences arising out of matrimony relating to dowry, etc., or the family disputes where the wrong is basically private or personal in nature and the parties have resolved their entire dispute. Stop. In this category of cases, High Court may quash criminal proceedings if in its view, because of the compromise between the offender and victim, the possibility of conviction is remote and bleak, and continuation of criminal case would put accused to great oppression and prejudice, and extreme injustice would be 2 of 6 caused to him by not quashing the criminal case despite full and complete settlement and compromise with the victim. Stop. In other words, the High Court must consider whether it would be unfair or contrary to the interest of justice to continue with the criminal proceeding, or continuation of the criminal proceeding would tantamount to abuse of process of law despite settlement and compromise between the victim and wrongdoer, and whether to secure the ends of justice. It is appropriate that criminal case is put to an end, and if the answer to the above questions is in affirmative, the High Court shall be well within its jurisdiction to quash the criminal proceeding. Stop. In view of the aforesaid discussion, we sum up and lay down the following principles by which the High Court would be guided in giving adequate treatment to the settlement between the parties and exercising its power under Section 482 of the Code while accepting the settlement and quashing the proceedings or refusing to accept the settlement with direction to continue with the criminal proceedings. Stop. Para. Power conferred under Section 482 of the Code is to be distinguished from the power which lies in the court to compound the offences under Section 320 of the Code. Stop. No doubt, under Section 482 of the Code, the High Court has inherent power to quash the criminal proceedings even in those cases which are not compoundable, where the parties have settled the matter between themselves. Stop. However, this power is to be exercised sparingly and with caution to prevent abuse of the process of any court. Stop. While exercising the power, the High Court is to form an opinion on either of the aforesaid two objectives. Stop. Such a power is not be exercised in those prosecutions which involve heinous and serious offences of mental depravity or offences like murder, rape, 3 of 6 dacoity, etc. Such offences are not private in nature and have a serious impact on society. Stop. Similarly, for offences alleged to have been committed under special statute like the Prevention of Corruption Act, or that offences committed by public servants while working in that capacity are not to be quashed merely on the basis of compromise between the victim and the offender. Stop. Para. In other words, those criminal cases having overwhelmingly and predominatingly civil character, particularly those arising out of commercial transactions or arising out of matrimonial relationship or family disputes, should be quashed when the parties have resolved their entire disputes among themselves. Stop. While exercising its power, the High Court is to examine as to whether the possibility of conviction is remote and bleak, and continuation of criminal cases would put the accused to great oppression and prejudice, and extreme injustice would be caused to him by not quashing the criminal cases. Stop. Offences under Section 307 IPC would fall in the category of heinous and serious offences, and therefore is to be generally treated as crime against the society and not against the individual alone. Stop. However, the High Court would not rest its decision merely because there is a mention of Section 307 IPC in the FIR or the charge is framed under this provision. Stop. It would be open to the High Court to examine as to whether incorporation of Section 307 IPC is there for the sake of it or the prosecution has collected sufficient evidence which is proved would lead to proving the charge under section 307 IPC. Stop. For this purpose, it would be open to the High Court to go by the nature of injury sustained, whether such injury is inflicted on the vital delicate parts of the body, nature of weapons used, etc. Stop. Medical report in respect of injuries suffered by the victim can generally be the guiding factor. Stop. On the basis of this prima facie analysis, the High Court can examine as to whether there is a strong possibility of conviction or the chances of conviction are remote and bleak. Stop. In the former case, it can refuse to accept the settlement and quash the criminal proceedings, whereas in the latter case, it would be permissible for the High Court to accept the plea compounding the offences based on complete settlement between the parties. Stop. At this stage, the court can also be swayed by the fact that the settlement between the parties is going to result in harmony between them, which may improve their future relationship. Stop.